I'm here to talk to you this afternoon about the new amendments that are about to come into force that have been brought in place by the Worker Protection Amendment of the Equality Act 2010 Act. What this piece of legislation does is make a couple of substantive amendments to the body of the Equality Act and introduce on employers a positive duty to take reasonable steps to prevent sexual harassment in the workplace. Now, a couple of important caveats to begin with. This new amendment covers sex harassment as opposed to harassment on the grounds of sex. So it's strictly speaking the duty under section 26(2) rather than the other bits of the legislation. Second important caveat is that the preventative duty is separate and distinct from the reasonable steps defence. So the Employment Tribunal will be required to consider any reasonable steps defence if you run one as a respondent. And in addition to that, it will have to consider these new amendments. They are two separate and distinct things that the Tribunal needs to question. So what we're going to look at is what the new bits of the Equality Act say, and then the very helpful, in my view, guidance that has been produced by the Equality and Human Rights Commission to give everybody an idea of the steps that employers are likely to have to take in order to comply with this new duty. It makes a couple of other smaller amendments to the Equality Act, but I've focused on the two big ones in the talk, and it's the sections replicated in the handout, but it is worth going through the wording of the legislation in detail. So it introduces a new section 40A, and this duty comes into force on the 26th, so just over a fortnight's time. An employer must take reasonable steps to prevent sexual harassment of employees of A in the course of their employment. And 2, sexual harassment means harassment of the kind described in 26(2). So that's the distinction I've already talked about between sexual harassment and harassment on the grounds of a protected characteristic. And what 3 says is a contravention is enforceable as an unlawful act, as enforceable only by the Commission or by an employment tribunal in accordance with section 124A, which we'll come on to. But it's important to note in relation to this that an employee cannot bring a freestanding claim in reliance on this new duty under section 40A. The only body that is entitled to bring individual action relying on this new section is the Equality and Human Rights Commission, who can bring separate enforcement action. If you have a claimant who is looking to bring a claim, you would bring a claim for sex harassment in the ordinary way, relying on section 26(2), and then the impact of section 40A will come on to deal with later. But it's a very important caveat to bear in mind. This doesn't create a new freestanding cause of action. It is an additional tool if you're a claimant, an additional string to your bow, if you like, on top of the original sex harassment duty. And if you're a respondent, it's an additional hurdle to think of when you're bringing a defence to a claim. The other substantive change to the Equality Act is an insertion at section 124A. Which affects the remedies that can be awarded where the tribunal is satisfied sex harassment has taken place. And again, we'll go through the wording of the legislation in full. So the section applies where an employment tribunal has found there has been a contravention of section 40, which involved harassment of the kind described in section 26(2), and the tribunal has ordered the respondent to pay compensation. We'll come on to deal with this in a moment, but that's an important thing to bear in mind. The tribunal has to find there has been a contravention of the duty under section 26(2), and that it was appropriate to order compensation in relation to that contravention. Once the tribunal's taken those steps, it has to consider whether and to what extent the respondent has also contravened section 40A, which is the new section that we just discussed a moment ago. If the tribunal is satisfied that the respondent has contravened section 40A, it may, and it's important to note the use of the word may here rather than the use of the word must, it may order the respondent to pay an amount to the complainant in addition to any compensation already awarded. And then lastly, subsection 4, the amount of any compensation must reflect the extent to which the respondent has contravened their duty and can be no more than 25% of the amount awarded originally in compensation. It is, I suspect, an approach that is going to be similar to breaches of the ACAS Code of Practice. So the tribunal will be looking at how serious the breach is of the duty, but applying a cap, much like with the ACAS uplift, at 25%. Now, the practical effect of this section means that where the tribunal has found sex harassment contrary to section 26.2, it has no discretion, it must consider whether the employer has complied with their duty at section 40A. So there's no discretion in relation to that point. It will be a good ground for appeal if you are a claimant if the tribunal doesn't deal with this. So the tribunal has to look at now whether the duty under section 40A is being complied with. The discretion comes, as I've already set out, slightly later, which is where the tribunal does have a discretion over whether to actually award an uplift or not. So they must consider the duty, but the tribunal, the wording in relation to an actual award is only may, so that remains within the tribunal's discretion. And what I've tried to set out at paragraph 9 of my handout is the approach that tribunals now in order have to take when considering a sex harassment claim contrary to section 26.2. So the first thing they have to do is obviously determine the question of liability under section 26.2. They then have to consider the relevant amount of compensation for that specific breach. They then consider the new duty under section 40A, and they lastly, when they've considered that duty, have to look at whether an uplift is appropriate and the level at which that uplift has to be awarded. Moving on then from what the legislation says to what the EHRC guidance says, as you might expect, it is lengthy, it is detailed, and I would certainly advise anybody who is practicing in this area to go and read it in full, because it is quite instructive. And until we get appellate authority on this point, it's likely to be your best course of guidance on how to advise your clients on how to deal with this issue. The first and probably most important thing to consider from the guidance is that the EHRC specifically say in their guidance that an employer is unlikely to be complying with their duty under section 40A if they haven't carried out a specific risk assessment as to the likelihood of sexual harassment. Any of you who've practiced in personal injury law will know that for other areas of work in the workplace, risk assessments are now fairly commonplace for manual handling, for other areas of your employment. My view is now employers ought to be considering risk assessments for sexual harassment as a matter of course, just like they would for other areas of their industry. Manual handling, health and safety, working at height, anything like that, you'd be required to have a risk assessment. My view is that now employers, and if you're advising your employer clients, they ought to be drafting these risk assessments and having them as a matter of course. If they don't have them, the guidance from the Equality and Human Rights Commission is they're unlikely to have complied with their duty. Specifically, in their guidance, and I've set this out in the handout, we'll run through a few of them now, the Equality and Human Rights Commission have identified factors which they think will increase the risk of harassment in a workplace. Things like having a male-dominated workforce, a workplace culture that permits crude, sexist banter or otherwise disrespectful behaviour. Taking a pause there, I'm sure a number of you in this room have had your head in the hands as soon as you've had an employer client say, oh, don't worry, it was just banter. Power imbalances are an important thing to consider. What's the makeup of your staff? Are most of your senior staff male and most of your junior staff female? If that's the case, it's likely to lead to an increased risk. Do you work in a place that permits consumption of alcohol? I won't go through all the rest of them, but social events, night working or isolated working, an insecure workforce, or no policies in place to respond to sexual harassment. We'll come back to policies in a moment. These are the sorts of things that when you are advising your clients on risk assessments, you want them to be specifically addressing, and you want them to be dealing with it exactly as they would deal with risk assessments that you would want to come across in personal injury cases. So you identify the risk factor, you highlight the consequences, and you specifically highlight steps you can take to mitigate that risk factor. If you're doing those sorts of things, then your risk assessments are likely to at least come close to complying with the guidance that the EHRC are setting out. In addition to a detailed risk assessment, what the EHRC are encouraging all employers to do, and again, my view is that certainly for anything other than very small employers, the approach that's likely to be taken when you litigate these issues is that it's going to be required, is that employers are going to need to produce and publish action plans as to how they are going to deal with the risks that they've identified. So again, as I said a moment ago, identify the specific risk factors and identify and publish, make it crystal clear to your workforce what the steps are you're going to take to mitigate and address those issues. I suspect that a pragmatic approach will be taken in that everybody will realise you're not going to be able to eliminate these risks entirely. And my view, we'll see, obviously it's a new area of law, I don't think tribunals are going to be expecting a counsel of perfection from employers, but they are going to be expecting employers to engage with this in a detailed and serious way and not just write it off as token efforts. If you have clients who aren't going to do that, who are going to just write this off like they might do other things, they're going to put themselves at risk, not only of increased awards of compensation, but also of potentially enforcement action from the EHRC. But in addition to risk assessments and action plans, it seems to me that the other really important thing that you ought to be advising your clients to do if you act for an employer, or if you act for claimants looking for employers who haven't done this, is engaging staff in training. My view now is, as a minimum, you're going to need to be telling your employers, if you've not done training on preventing sexual harassment in the workplace, you ought to start doing it now. Because if you haven't done the training, in my view, it's going to be difficult to demonstrate to a tribunal how you've taken reasonable steps to prevent harassment in the workplace. So risk assessments, action plans, training are going to be absolutely vital, in my view, if you act for employer clients, in protecting them against inflated claims relying on this section. Looking now at the 8-step guide, I've set out the headlines in my handout, but I'll run through them in more detail now. Obviously, the link is there. Much like with the general guidance, my view is that this 8-step guide is incredibly useful and detailed, and if you're not already pointing your clients to it, you should be. Step 1, develop an effective anti-harassment policy. So again, policies are crucial. Make sure it's well written, make sure it's well publicised, make sure everyone is well aware of it. Engage your staff, training courses, refresher courses, publication of policies. Make sure that that your clients can say they have made their employees aware of the existence of these things and that they're aware of the consequences of it. Step 3, risk assessments. I won't go into those any more detail than I already have. Step 4, reporting. Do your employer clients have steps in place for effective reporting of incidents of sex harassment? What the EHRC, yeah, I get them confused with the Convention on Human Rights, but is keep centralised confidential records and make sure you keep the records carefully, keep them dated, and if possible, try and introduce systems where anonymous reporting is possible. Step 5, training. Been over that. I won't go over it in much more detail. Step 6, make sure that you know what to do and your clients have good advice on what to do in the event that a harassment complaint is made. Deal with it promptly, deal with it properly, make sure there's no suggestion that the person who makes the complaint is going to be victimised for making the complaint. All too often, cases of not just sexual harassment, but other cases of harassment turn very easily into victimisation claims because the person who's made the complaint isn't dealt with properly by the employer client. Step 7 relates to dealing with harassment by third parties. The amendment to the legislation doesn't specifically introduce a duty in relation to harassment by third parties. Save for the guidance emphasises it's not just your own staff. It's not just staff-on-staff complaints that employers have to protect against, but if they come into contact with other individuals who aren't employed by the workplace, you are under a duty to protect your staff from harassment by then. And lastly, step 8, monitor and evaluate your actions. Go back over your policies, go back over your risk assessments, go back over your training. Make sure it's in date, make sure it's developed regularly, and if you're seeing patterns, if you're seeing developments of behaviours in certain areas, tailor your training, tailor your risk assessments to reflect those risks. As I say, until appellate authority, and I'm no doubt we'll be getting appellate authority on this as soon as the claims start to come through, until appellate authority does come through, your best place to look for guidance when you're providing advice to your clients is the EHRC guidance. Make sure they're familiar with it and the steps that are set out in it. And I've given a link to it there.